Imagine you get a simple traffic ticket. You decide you want to contest it, so you wait for your day in court.
Yeah.
And you wait. And you just keep waiting, like 10 years go by.
Which, I mean, sounds completely absurd today, but that was the reality.
Right. In India, during the late 1990s and early 2000s, the judicial system was so paralyzed, operating with this just staggering deficit of judges, that a minor violation could plunge you into a decade-long purgatory.
The wait for a trial basically became a brutal punishment all by itself.
Exactly. So when a fundamental democratic system is that profoundly broken, who steps in? Do we wait for politicians who have ignored the problem for decades? Or do the judges sitting on the bench grab the pen, rewrite the rules of the game, and just save the day?
And that tension is really the core of our deep dive today. We're looking at a stack of legal texts called Interpretation of Statutes case laws.
Yeah, and specifically focusing on two massive Indian Supreme Court rulings from 2002.
Right, the P. Ramachandra Rao and Padma Sundara Rao cases. And, on the surface, statutory interpretation sounds like dry academic theory.
Oh, absolutely.
But in reality, it dictates whether a citizen spends a decade in legal limbo or whether the government can just seize your private property on a whim.
Which is terrifying. Our mission today is to find that exact razor-thin line between a judge interpreting the law and a judge illegally rewriting it.
It's a huge constitutional question.
It really is. And we have to start with the sheer agony of that wait, because it completely sets the stage for this showdown. The first major case in our sources, P. Ramachandra Rao, centers on Article 21 of the Indian Constitution.
Which is the right to life and personal liberty.
Right. And previous courts had looked at this article and declared that, well, life and liberty must inherently include the right to a speedy trial.
Because the mental agony, the expense, the strain of endless criminal proceedings, it just destroys you.
Yeah, imagine being accused of something and having that accusation hang over your head for a decade. It's like waiting for a critical medical test result, but the doctor...
It takes 10 years to call you back.
Exactly. You can't plan your life, you can't get certain jobs, you are just trapped. So if the Constitution guarantees a speedy trial, why wasn't anyone getting one?
Well, the sources point us to this highly revealing document, the Law Commission of India's 120th report on manpower planning in judiciary. And the root cause comes down to simple, devastating math.
Let's hear it.
At the time of this report, India had 10.5 judges per million people.
Wait, I need that to sink in for whoever's listening to this. 10.5 judges to serve an entire million people.
Yeah. To give you the comparative data from the same report, the United States had 107 judges per million.
Wow.
Canada had 75. England had 51. The Law Commission practically begged for a five-fold increase in judicial manpower just to stop the backlog from growing.
Just to stop it from growing, not even clear it.
Right. But the shortage of judges was really just the tip of the iceberg. The text outlines a cascading failure across the entire criminal justice infrastructure.
Yeah, the sources list these everyday logistical nightmares, like trials were delayed because lawyers would just go on strike.
Or, incredibly, the police were simply too busy with what the text calls VIP duties to actually transport prisoners.
Yeah, just basic law and order enforcement meant they couldn't bring under-trial prisoners from the jail to the courthouse.
Exactly. You could have a judge ready, a lawyer ready, but the police just didn't have the van or the officers to bring you to your own trial.
That is insane. And on top of that, the appointment of public prosecutors had become heavily politicized,
which led to endless vacancies and delays. You had an executive branch dragging its feet, a police force lacking basic transport, and a legislature that refused to allocate funding.
So everyone is pointing fingers.
Pretty much. The Law Commission report actually included this deeply cynical observation. They noted that the reorganization of the judiciary is, and I'm quoting here, at the one and at the same time, everybody's concern, and therefore, nobody's concern.
Man, that hits hard. So the politicians are sitting on their hands. The system is crushing regular people. And this is where a group of Supreme Court judges decided they had just seen enough.
Right. The interventions begin.
Yeah, in the mid to late 1990s, smaller groups of judges on the Supreme Court, we could think of them as these rebel benches, decided to force the issue.
In cases like Common Cause and Raj Deo Sharma, they basically built a judicial stopwatch.
A stopwatch. They created strict mathematical formulas to terminate delayed cases.
Right. So, for example, they ruled that for offenses punishable by up to 7 years in prison, if the trial court didn't finish examining witnesses within 2 years.
The court was ordered to just close the prosecution's evidence entirely. Boom, time is up.
Exactly. And for traffic offenses, they said if the summons weren't served to the accused within 2 years, the case just had to be closed and the accused discharged.
Honestly. Reading this, my first reaction was just relief. Like,
Mhm.
finally, someone is doing something.
Oh, it is incredibly tempting to cheer for that outcome.
Here's where it gets really interesting. The judges got so fed up that they practically invented a statute of limitations out of thin air. They drew a hard line in the sand to force the executive branch to act.
But from a structural standpoint, those rebel benches threw the entire legal system into chaos.
Wait, why? It sounds like they were just fixing a broken system.
Because a few years earlier, an older foundational five-judge Constitution bench in a case called A.R. Anchele had looked at this exact same problem and explicitly ruled that you cannot fix a rigid time limit for trials.
But why not? I mean, if a 2-year limit gets innocent people out of the system, why would an older court forbid it?
Well, because that older court recognized that justice is entirely relative, how do you apply the exact same 2-year stopwatch to a simple bicycle theft and, like, a sprawling international corporate fraud case?
Oh, with like 80 witnesses and offshore bank accounts?
Right. What happens if the accused is the one intentionally delaying the trial by filing frivolous motions just to run out the clock?
I didn't think about that.
Or what if the local courthouse was closed due to an earthquake? The variables are just infinite.
So a one-size-fits-all timeline is impossible.
Exactly. The older bench argued you cannot slap a universal expiration date on criminal proceedings without inadvertently letting, dangerous criminals walk free just because a police van broke down.
Okay, so we have a massive collision of legal philosophy here. An older, larger bench of 5 judges says no rigid time limits. The real world is too complicated.
And then a few years later, smaller benches of judges say, we don't care about the complications, the system is destroying lives, we are imposing hard deadlines.
That sets up a huge showdown. Can these newer judges just ignore the older ruling?
Well, this specific conflict paralyzed the lower courts. Judges across the country didn't know which Supreme Court ruling to follow.
It must have been total chaos on the ground.
It was. The confusion became so severe that the Supreme Court had to convene a massive 7-judge bench in the P. Ramachandra Rao case to settle the law permanently.
And this is the climax of the first document. This 7-judge bench completely struck down the stopwatch. They abolished the time limits invented by those smaller rebel benches.
They absolutely did.
Wait, hold on. You're telling me the highest court in the land looked at a system where innocent people are waiting a decade for a trial, and their response was to strip away the one tool that was actually forcing cases to close?
Yes.
How does that serve justice?
It serves the long-term survival of the democratic system, which is what the 7-judge bench had to protect. They struck down the time limits for 2 main reasons.
Okay, break them down for me.
First, the doctrine of precedence. A smaller bench of judges is legally bound by the decisions of a larger bench.
So the smaller rebel benches simply had no legal authority to overrule the older 5-judge bench.
Precisely. But the second reason is the crucial one for our deep dive. The 7-judge bench declared those time limits to be impermissible judicial legislation.
Impermissible judicial legislation. So they basically accused their fellow judges of writing laws instead of interpreting them.
Correct. We have to look at the mechanical separation of powers. The text quotes a famous legal scholar, Salmond, on the principles of jurisprudence.
What did he say?
He wrote, legislators can lay down rules purely for the future, but the courts, insofar as they create law, can do so only in application to the cases before them.
Meaning, a judge's job is to solve the specific dispute sitting on the desk in front of them today. They aren't elected to write a sweeping procedural code for the entire country.
Right, and the sources also cite a monograph by Professor S.P. Saith that breaks down the practical limitations of the courts.
Like what?
Well, judges do not have research departments to run national pilot programs. They lack the facilities to gather broad macroeconomic data.
That makes sense. They're just lawyers in robes, essentially.
Exactly. They rely almost entirely on the 2 partisan lawyers standing in front of them to explain a problem. And most importantly, judges do not control the budget.
That is the mechanical piece of the puzzle. If a judge orders a strict 2-year deadline for all trials, they don't have the power to magically summon the funding to hire the clerks needed to process the paperwork.
Right. They can't appropriate funds to buy the police vans to transport the prisoners.
They are mandating a massive systemic overhaul without providing any of the machinery to achieve it.
Precisely. Allowing judges to legislate from the bench, even with noble intentions, creates a profound danger. You're giving a small group of unelected officials the power to write the rules without the tools to see if they actually work.
And without any mechanism for the voters to hold them accountable.
Exactly. The court in P. Ramachandra Rao essentially told the government, look, we see your 10.5 judges per million people. We see the system is collapsing.
But we will not step outside our constitutional boundaries to cover up your failures.
Yes, they said, it is your constitutional obligation to fund and fix this.
Wow. I understand the logic. The courts are saying, we are the referees, we are not the rule makers. We won't bend the law to save a citizen from an endless trial.
It's a harsh reality.
But, if I'm listening to this, I'm probably screaming at my phone right now. Because I want to know if the courts hold the government to that same brutal, unbending standard.
Oh, that is the perfect pivot.
Right. Because when the government messes up its own procedures, do the judges shrug and say, tough luck? Or do they suddenly find a way to bend the rules?
That brilliant question bridges us directly into our second major source document, the Padma Sundara Rao case.
So this ruling tests whether the judiciary's strict self-restraint applies when the state is the one asking for a favor.
Exactly. We're shifting from criminal trials to the Land Acquisition Act. This is the law that allows the government to force the sale of private land for public use.
Like building a highway or a dam. Taking someone's private property is one of the most aggressive powers a government has.
Which is exactly why the legislature placed very strict statutory time limits on the process.
How do the mechanics work?
It works like this. The government points at your land and issues an initial notification saying, we might want this. That starts a ticking clock. The statute gives them exactly 1 year to come back and issue an official, finalized declaration that they are definitely taking it.
And if they miss that 1 year deadline,
the entire process expires. Your land is safe.
It sounds straightforward. The government gets 1 year to do the paperwork.
It is straightforward until the government makes a procedural error. Suppose they issue that official declaration within the 1 year window, but the landowner discovers the government skipped a mandatory public hearing.
So they take the government to court.
Right. The judge looks at the error and quashes the declaration. The paperwork is just thrown in the trash.
But the government still wants to build the highway, obviously.
So they ask a crucial question. Do we get a fresh 1 year clock to try again?
Oh? What did the court say?
Well, previous, more lenient courts had said yes. A 3-judge bench in an earlier case argued that if you don't grant the government extra time to fix their mistakes, the public purpose would be frustrated.
So the highway would never get built because of a typo or a missed meeting?
Right, so those earlier judges stretched the language of the statute to give the government a do-over.
But wait, the sources outline exactly how compensation works under the Land Acquisition Act. And it completely changes the math on this.
Yes, it does.
Because the amount of money the government pays you for your land is pegged to the date of that very first notification.
The day they originally pointed at your land. Sections 11 and 23 of the Act make that explicitly clear. The valuation date is frozen.
So if the government messes up and a lenient court gives them a fresh 1 year clock to try again, the process drags into year 2 or year 3.
Right.
During that entire time, the citizens' land is tied up in legal purgatory. They can't sell it, they can't develop it, and the money they will eventually get paid is based on property values from 3 years ago.
It's completely wild.
The government's incompetence directly robs the citizen of their property's appreciation. Why should the citizen pay the price for a government error?
That profound financial unfairness is exactly the dynamic the Supreme Court addressed in Padma Sundara Rao. And to resolve it, they relied on this really fantastic legal concept of statutory interpretation called casus omissus.
Casus omissus, what does that mean?
It translates from Latin as a case omitted. It refers to a situation that the legislature simply forgot to include in the text of the law.
Okay, so how does a court handle a case omitted? Do they just fill in the blank?
No, the absolute rule of casus omissus is that courts cannot supply a legislative omission.
Got it.
Think of it like a recipe. If a cookbook tells you to bake a cake for 30 minutes, but the author completely forgot to write down the oven temperature.
A judge reading that recipe cannot just mandate that the temperature must be 350 degrees.
Exactly. Even if 350 degrees makes perfect logical sense, the judge doesn't have the authority to write the recipe. They have to send it back to the chef.
So applied to the Land Acquisition Act, the judges look at the law and say, the legislature gave you 1 year. They did not write a clause granting you a do-over if a court throws out your paperwork.
Right.
And we cannot write that clause for you.
The Supreme Court came down like a hammer. They explicitly rejected the reasoning of those earlier lenient courts. The language of the act was plain and unambiguous.
The time limit is the time limit.
Exactly. The court quoted the legendary American judge, Learned Hand, who famously cautioned that while statutes should not be construed like rigid theorems of geometry, a judge's interpretation must always be anchored to the actual words used.
So you have to find the intention of the law in the words printed on the page, not in what you assume the politicians meant to say or what would be most convenient for the highway department.
The court acknowledged that sometimes a literal reading leads to a frustrating result for the state, but they stated plainly if a law is poorly drafted, or if it leads to a dead end that frustrates the government's infrastructure plans, it is the sole responsibility of the legislature to pass an amendment.
It is not the court's job to stretch the English language to fix the government's careless paperwork.
Exactly.
I find it so fascinating that we see the exact same judicial philosophy applied to two completely different scenarios.
It was just striking.
In the criminal trials, they refused to invent a timeline to save the citizen. In the land acquisition, they refused to invent a timeline to save the government. They apply the rule universally.
It is a profound demonstration of judicial self-restraint. In both P. Ramachandra Rao and Padma Sundara Rao, the highest court in the land is deliberately limiting its own power. They are refusing the temptation to become a super legislature.
When we pull all of these threads together, what is the ultimate takeaway for someone navigating the modern world?
Well, I think it's about the boundaries of power.
Yeah, true justice in a democracy isn't just about forcing the right outcome in one specific case. It is about maintaining the integrity of the entire structure. When judges start acting like politicians, even to protect the little guy, they break the machinery. They usurp the power of the elected representatives. They mandate solutions they cannot fund.
Right.
So the next time you see a headline about a controversial Supreme Court decision, look past the immediate outrage. Ask yourself the structural question. Are the judges interpreting the words actually written on the page? Or are they quietly trying to write a new law because they believe they know better than the voters?
I think that is the perfect lens for viewing these decisions. But as we close this deep dive, I want to leave you with a final, rather unsettling thought built directly on these sources.
Oh, lay it on me.
The Supreme Court decisively ruled that it cannot legislate. It cannot invent deadlines to force speedy trials, and it declared that fixing the crippling shortage of judges, that 10.5 judges per million statistic, is entirely the government's constitutional obligation.
The court firmly handed the responsibility back to the politicians.
They did. But here is the lingering question. What happens when the politicians simply refuse to accept that responsibility? If the courts are constitutionally barred from stepping in to force a solution, and the government refuses to allocate the funding year after year, decade after decade, who is left to protect the citizen?
That is heavy.
When the justice system inevitably collapses under the weight of its own backlog, and the wait for a trial truly does become a lifelong punishment, at what point does principled judicial restraint just become another word for abandoning the innocent?
And with that image of a system teetering on the edge of collapse, we will leave you to ponder where the ultimate responsibility lies. Thanks for joining us on this deep dive.